This is Jessica Lee Johnson's final shot at staying free, but this courtroom isn't buying excuses. Today, you're watching a judge weigh 5 years of failed probation, ignored CPS requirements, and parenting classes that never even started. What began in 2021 as a deferred sentence for serious drug possession is now spiraling into a full-blown prison term. And when you hear Jessica's explanation, you won't know whether to scream in frustration or feel sympathy. This isn't just a case about skipped check-ins. This is about addiction, responsibility, and a family on the brink. And the judge? He's not here for second or third chances. Stick around because this sentencing is about to drop harder than she ever expected.
What have you completed?
I haven't got to complete anything else.
Okay.
That's what I'm saying. Now that I'm in more of a stable.
Court is calling 2021 CR 7243, State of Texas versus Jessica Lee Johnson. Can I have parties announced for the record for the state?
Thank you, for the state, Your Honor.
Defense?
John Robertson from Ms. Johnson.
All right, and are you Jessica Johnson?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. First, state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. And second, state's motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jessica Lee Johnson, who was placed on deferred adjudication in 2021 CR 7243 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 8, 2021 for a period of 5 years? Is that you?
Ma'am.
Let's pause here. Jessica was given deferred adjudication for possessing a controlled substance between 4 and 200 grams. That's not a petty offense. Deferred adjudication is a form of mercy. If she followed the rules, she could have avoided a conviction altogether. But what happens when someone burns through every second chance? And look at those months: April, May, November, December, January. We're not talking one missed check-in. This is chronic. Let us know in the comments, should failing to report this often automatically mean prison time?
All right, state.
This is on the first motion, Judge. Violated condition number 2, on or about the 6th day of February. Violated condition number 4, in Bexar County, Texas, the defendant, Jessica Lee Johnson, did then and there fail to report to the supervision officer as directed for the months of April, May, November, December 2022, and January 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And then, Judge, this is on the second state's motion to supplement pending motion to enter. Violated condition number 4, in Bexar County, Texas, the defendant, Jessica Lee Johnson, did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, and August 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
You heard that right. Jessica pled true to multiple violations spanning 6 more months. That's essentially an admission to continued non-compliance over a full year. This is now her 3rd motion to revoke. Think about that. The court gave her 3 different opportunities to course correct. At what point does leniency become a loophole? What would you do if you were the judge here? Give her another shot or slam the gavel on a hard sentence?
And Your Honor, we waived and abandoned the other violations alleged in the motions.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation of conditions 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find violations 4 and 4 true. Is there a proposed agreement?
No, Your Honor.
All right, state, what are you requesting?
Your Honor, we're asking that you grant the motion, adjudicate the defendant guilty, and sentence the defendant to 10 years to do.
All right, defense, what are you requesting?
Your Honor, I'm requesting the court consider something other than revocation, or if revocation is going to be imposed, that
Now her attorney steps in, painting a picture of a struggling woman trying to juggle her dad's declining health and a complicated relocation. It's emotional, no doubt. And when you hear Jessica speak next, you'll notice she doesn't shy away from admitting her failures. But it's also strategic. This moment is about swaying the judge emotionally, not legally. The question is, should empathy outweigh accountability when someone's had years to comply?
A number less than 10 would be more appropriate. Ms. Johnson would like to address the court, kind of explain her situation. She advised me that her situation recently has actually improved as far as the stability of her personal life. She's had a lot on her plate the last year and a half or so. Has admittedly not performed well on probation, but she would like to address the court and explain it.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jessica Johnson.
All right, what would you like to say?
Just now that I'm in a better, stable environment, and my dad's health is a little better under control. And I was gonna try to ask for a final chance with probation being in the new county that we've relocated to. Me going away will leave my 18-year-old take care of my dad by himself.
Here, Jessica makes a heartfelt plea, not just for herself, but for her father and her 18-year-old. It's the classic family burden defense. But the prosecution could argue, where was this concern during those 12 missed check-ins? It's a powerful emotional appeal, but is it enough to erase nearly 4 years of non-performance? And would granting her probation again actually help her, or just delay the inevitable?
All right, what have you been doing while you've been on probation? Because you have not been reporting.
Yes, ma'am. Well, we did move out to Pipe Creek, Texas. And my dad's health was up and down in the middle of us relocating. So we actually ended up leaving behind, half of our belongings at the old house and not even going back for it because my dad having to have surgery and being in and out the hospital.
Let me ask you this. Did you ever provide the location of the children?
Yes, ma'am.
Okay, so because this is your third motion to revoke.
Yes, ma'am.
And the first one, it's
They're still in the same place with my mom that they've been the whole time because of my dad's health being up and down and us relocating. I didn't want to move my mom and them, to one county when we're moving in the middle of.
tell probation you were moving?
No, ma'am.
This part hits hard. Jessica was previously instructed to provide proof of residency and follow CPS requirements. And when asked about it, it's excuse after excuse. The probation officer went on leave. She never made it to Austin. CPS said the case was closed, but nothing got completed, not even parenting classes. How much of that is on her and how much is the system failing to follow through? Let's hear what you think. Drop your take in the comments.
Right, because the first motion to revoke,
Right.
it was you were to provide proof of residency in Austin
Right.
and follow through on your CPS requirements. Did you complete CPS?
When I contacted them, when I got out, they said that the case was closed and there was nothing else for me to complete or do with them.
All right. Did you do felony drug court in Austin?
No, ma'am. I actually never ended up leaving. They had my probation officer that I had went on, I don't know if it was a vacation or what. She ended up not coming back and I had got like a new probation officer. So I never even got to actually leave to Austin. They revoked it that time.
All right. Did you complete parenting classes?
No, ma'am, I didn't. With my dad and us moving, I didn't get to start anything. I did sign up while I was in the
So
county waiting.
you've been on probation since September 2021.
Right.
What have you completed?
I haven't got to complete anything, ma'am.
At this moment, Jessica makes one final plea, claiming she's now in a more stable environment. But the timing is key. She's only pushing for compliance now that she's staring down 20 years in prison. Should the court reward last minute promises? Or is this just another attempt to dodge consequences after years of deflection? Think of the precedent this sets.
Okay.
That's what I'm saying. Now that I'm in more of a stable environment and situated and my dad a little bit more under control, I would be able to start and do everything that I was supposed to originally do.
All right, the court is finding violations 4, 4, and true. The court is going to grant the motion, find you guilty. Would parties like to speak to time? I know State, you said you're asking for 10 years.
Your Honor, I just think a more moderate sentence would be appropriate for her. She's got a lot on her plate. She's got responsibilities she needs to get back to. I would ask the court to consider a sentence closer to 2 than 10, given the situation.
Just one moment.
Here it is. The hammer drops. The court finds her guilty and sentences her to 10 years in prison. No probation, no alternatives, just a straight decade behind bars. And while her defense asked for closer to 2 years, the judge clearly felt this pattern of avoidance and missed opportunities warranted the full weight of the law. Is it harsh or finally justified?
All right, court will find you guilty, grant the motion, sentence you to 10 years in the prison. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication.
The judge now outlines the consequences of her felony conviction, including the loss of firearm rights and limitations on appeal. These aren't just legal technicalities. This is a permanent mark on her record. It's a reminder that once you're convicted of a felony, your rights and your future shrink dramatically. The question is, could this have been avoided at any point along the way?
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to the.
This is a brief moment, but a big one. Jessica is offered a chance to request a therapeutic community while in custody. It doesn't reduce her sentence, but it could offer structure and treatment, maybe even redemption, but only if she follows through. Given her track record, that's a big if. Would you trust her to make the most of it?
Attorney, do you understand?
Yes.
And counsel, if she would like the therapeutic community, I can recommend that. It doesn't increase the length of time that you're in custody. Would you like that or no?
Yes.
All right. You'll still have to request it yourself. All right. Good luck to you.
And just like that, it's over. A woman who had every opportunity to turn her life around now faces 10 years in prison. There's no chaos in the courtroom, no tears, just silence. It's as if everyone knew this was coming, even Jessica. Let's break it down. Jessica Lee Johnson was granted deferred adjudication for a serious drug offense. In return, she was supposed to follow through on basic requirements, reporting to probation, attending parenting classes, fulfilling CPS obligations. But in nearly 4 years, she completed nothing. 3 revocations later, the court finally lost patience and handed her a 10-year sentence. Was it avoidable? Absolutely. Was it deserved? That's for you to decide. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.